Hello everyone, this is group 2 and in this section we will talk about the Aaron Swartz case study. I'm Aynaz and my group mates are Rifat, Muhammad Karim and Han Kong who will talk about the Aaron Swartz. Our agenda is as follows. At first, we will talk about an overview and summary of the case and also the introduction about him and his background. Next section will be the hacking technical analysis. The next section will be the charge, prosecution, law, and legislation reform. And at last, we will have the conclusion and reference. So let's talk about who was Aaron Swartz and a little bit about his case study. So, Aaron Hill Swartz was an American entrepreneur and computer programmer. He was a founding member of the Reddit social news platform, of the publication format Markdown, the online feed format RSS, the website framework web.py were among the groundbreaking innovations created by him. And in 2005, Notebug Inc. was established and he was given the distinction of co-founding it. He also was a well-known author, activist, and political activist, with most of his activities centered on raising community consciousness and engaging in successful internet activism. After he used his MIT guest user account to download JSTOR's academic journal article, Swartz was taken into custody and accused of breaking and entering in 2011. He was facing a total of 50 years imprisonment and a $1 million punishment after being accused with 11 breaches of the Computer Fraud and Abuse Act and 2 wire fraud charges. Swartz and his attorney team agreed with a counteroffer after rejecting the government's suggestion of a 6-month jail term. Their counteroffer got rejected and his body was found 2 days later in his Brooklyn residence where he had hung himself. Swartz has been attributed with creating the Internet as it is today because he advocated for an unrestricted, open, and a free Internet. So let's talk a little bit about his early life and his childhood. He was born in Highland Park on November 8, 1986. Swartz was a talented youngster who showed great promise at a young age. The majority of his time was spent studying computer science, programming, the internet, and online culture. He started to develop the impulses that would almost immediately characterize him for the rest of his life, like the constant urge to work on several projects at once, the drive to organize data, and the demand to repair damaged systems. He began teaching himself to read when he was 3 years old, and by the time he was in primary school, he was creating an ATM for a class project. He attended the private Chicago area school North Shore Country Day School until the 9th grade. He quitted high school the next year and started taking a number of courses related to the computer in the Chicago region. When he was 13 years old, Swartz won the Ars Digita Award. The award was open to young people who had produced useful, informative, and collaborative non-commercial websites. In December of the following year, 2000, he became a member of the steering team that drafted the RSS-1 web syndication definition. Uh, to talk about his career, actually, after being admitted to Stanford University, Swartz applied to work on the inaugural Summer Founders Program of Y Combinator named Infogamy, which was developed to produce a flexible content management system to build visually appealing and rich websites or a wiki-style platform for structured data. In 2005 summer, Swartz collaborated with Infogamy co-founder Simon Carstensen. He started regularly blogging at this time. His articles addressed a variety of subjects such as his time at Stanford, copyright law, and his involvement in the development of Creative Commons. In 2006, he made the decision not to go back to Stanford and kept working at Infogamy. He developed web.py, a Python web application framework, while he was still employed by the firm since he had become tired of existing Python-based systems. He joined the Reddit founders, a different startup from Y Combinator, in the early fall of 2005 to assist them with writing the code base for it in Lisp using Python and web.py. Notwithstanding the fact that Infogamy was abandoned once Wired magazine's publisher, Connas Publications, took over, purchased not a bug, its software was used to power the Open Library project of the Internet Archive. After Infogamy was unable to obtain more finance, Reddit and Infogamy merged in November 2005. Now, the bug was founded in that year and advanced the both of those products. Despite the fact that both projects struggled as first, Reddit quickly gained greater popularity. Swartz had to move his whole business to San Francisco after Wired acquired Notabog, where he started working at Wired main office. He eventually departed from the firm after realizing that office life was not for him. Together with Carstensen, Swartz founded the company Jotted. They were making yet another effort to use Python to build a content management system, which is Markdown driven. So Aaron Swartz, as a software developer, actually he started to work with the World Wide Web Consortium in 2001, global organization which creates standards to ensure the web's expansion. In 2004, Swartz produced the RFC 3870 application media type registration while working for World Wide Web Consortium's RDF core working group. The paper describes a novel kind of media called RDF or XML that was created to power a semantic web. Actually, young Aaron wasn't concerned about patenting his innovations or restricting access to them. Swartz was the author of Markdown's HTML to text converter and one among the primary developers of Markdown, a lightweight markup language with syntax for structuring plain text that can be quickly changed to HTML and other formats using a program with the same name. Swartz created the ATX language in 2002 and used it to create Markdown syntax. Swartz has acquired the whole bibliographic record from the Library of Congress, maybe around 2006, but it wasn't known until after his suicide. Although there were often payments associated with accessing the data, copyright rules in the US did not prohibit its use because it was an official document. Then, to make information accessible to everyone, he posted the information on Open Library. Later on, the Copyright Office gave its approval. Some reports claim that the material was uploaded to the Internet Archive via the Scriblio library system at Plymouth State University. Notwithstanding this, his file served as Open Library's starting point. Virgil Griff and he and Swartz worked together to create Tor to Web, an HTTP proxy for services hidden behind Tor. It acts as a bridge between Tor and common web browsers. DeadDrop also was developed and put into use by Swartz in collaboration with James Dolan and Kevin Paulson. The technology provides a mechanism to deliver electronic papers to unidentified parties without raising the danger of revelation. It's named after the espionage tradecraft technique used to transmit goods or information between two people utilizing a hidden location. As an activist, Watchdog.net was founded by Aaron Swartz in 2008. The website was developed to gather the first-see information on politicians. It concentrated mainly on the various funding sources used by different politicians. In 2009, Swartz helped to shape the Progressive Change Champion team to further his education on successful advocacy. Together with the committee, he organized his first active activity. They gathered thousands of signatures on a petition asking for a senator to be nominated who would vote in favor of health care reform, fulfilling Senator Ted Kennedy's final desire. In 2010, Swartz was a founder member of Demand Progress, which is a political advocacy organization working to educate the public about problems such as government reform, civil liberties, and several other topics. Additionally, it encourages citizens to contact public authorities and support pressure techniques online. One of the most well-known characters in the Prevent passage of the Stop Online Piracy Act known as SOFA, movement was Swartz. Although the measure was intended to reduce online copyright infringement, others argued that it would have made it simpler for the government to shut any websites it believed to be infringing copyrights and that would have placed an unreasonably heavy load on Internet service providers. The bill eventually failed to pass. He used a script in 2008 to automatically download 2.7 million records from the public access to court electronic records website, which houses all federal court records for the United States. One needed to pay online in order to obtain PACER documents. By using his program to circumvent the payment mechanism, Swartz gave the texts, which were open to the public, free access. As a result, the FBI looked into him. However, his lawsuit was dropped since no official complaint had been filed. Let's continue with his arrest and trial section. Aaron, who was 24 at the time of his arrest, was charged with computer fraud, electronic fraud, illegal information acquiring from a secured computer, and reckless computer damage on January 6, 2011. Swartz was specifically charged with breaking the JSTOR's term of service and downloading over 4 million papers from the academic article archives and evading MIT's efforts to prevent him. The report claims that in 2010, Swartz purchased a laptop and signed up for the MIT network using a false account. Swartz created a Python script on his machine, which enables him to download papers quickly from JSTOR. After discovering the script by JSTOR, the IP address was blacklisted. In order to get around JSTOR and MIT's attempts to restrict access, the report claims that Swartz altered his IP address and MAC address many times. A few weeks later, JSTOR restored MIT's network connection, but Swartz had modified his method of downloading the information. He was charged with entering a room that had networking equipment and concealing his laptop there so that no one can see it. By connecting directly to the servers, he was able to get through the blocking and filtering systems in place and successfully complete his download. The police report details how, despite wearing a mask to conceal his face, Swartz's cycling helmet was clearly captured on camera as he attempted to retrieve his laptop from where it had been hidden. The U.S. authorities claim that Swartz most likely downloaded the publications in order to freely disseminate them over P2P networks. JSTOR acknowledged that the content that was downloaded had not been put to use, transmitted, or shared. However, according to government officials, downloading several papers in bulk from scholarly publications is a criminal crime that should be penalized with imprisonment. The intriguing aspect is that Swartz got free access to all of those downloaded publications since he was an MIT student. The usage of a script to download several articles represented a criminal mentality. He was indicted on state counts of grand larceny, unauthorized access to a computer network, and breaking and entering with intent on November 17, 2011. The state accusations, meanwhile, were eventually abandoned. On September 12, 2012, 9 additional felony charges were added, putting Swartz's sentence at 50 years and a fine of $1 million. He was given the option to admit guilt to 13 federal offenses in exchange for a 6-month sentence in a minimum security facility. Swartz turned down the proposal, and he was discovered dead in his Brooklyn apartment on the evening of January 11th of 2013 by his girlfriend Taryn Kaufman. He hung himself, according to a spokesman for New York's medical examiner. There wasn't any suicide note there, but he utilized his extraordinary abilities as a programmer and engineer not to benefit himself, but to make the internet and the world a fairer, better place, according to a statement posted on the memorial website that Swartz family and partner built. My groupmate will continue.
Hi everyone, hope all of you are doing well. So before we dive deep into the case, I thought it would be convenient to look at what cybercrime is and some of their liabilities in the real world and virtual world. We can relate this with our case at hand and really see why Aaron was prosecuted. In general, cybercrimes are committed against a computer or by means of a computer. They differ in many ways from typical crimes, and they do have similarities as well. Both cybercrime and crime results in the imposition of criminal liability. We will look at some of the common liabilities in the upcoming slide. In the Anglo-American common law tradition, a crime consists of four elements: conduct, mental state, attendant circumstances, and a forbidden result or harm, and both crimes and cybercrimes share these constituent elements. So crimes as traditionally conceived are committed in the real world, in our shared physical reality, whereas cyber domain and cybercrime exists along with but apart from the physical world. It is a shared conceptual reality, a virtual world. Since it is not in the physical domain, many argues if the crimes conducted here should have the same consequences as the crime in the real world. Let's look at the liabilities in the real world and the virtual world. So, burglary is generally defined as entering a building or occupied structure or separately secured or occupied portion thereof with purpose to commit an offense therein, unless the premises are at the time open to the public or the actor is licensed or privileged to enter. The essence of the offense is an unlawful entry into an area for the purpose of committing an offense, such as theft, once the entry is complete. The obvious cyber analogies to this offense are hacking and cracking. An offender commits forgery if acting with the purpose of defrauding or injuring someone or with the knowledge that they are facilitating a fraud or injury to be perpetrated by anyone that does any of the following. So if they alters a writing of another without the owner's authorization, or makes, completes, executes, authenticates, issues, or transfers any writing so that it purports to be the act of another who did not authorize that act. Essentially, forgery consists of knowingly altering a document and or knowingly using an altered document for the purpose of defrauding someone. The offense of fraud or false pretenses consists of an offender's knowingly making a false representation of a material, present, or past fact to a victim with the purpose of defrauding the victim and thereby causing the victim to transfer property or something of value to the offender. In theft offenses, the perpetrator takes someone's property without the victim's permission. In fraud offenses, the perpetrator uses false statement and misrepresentation to persuade the victim to part with property or the things of value. Most places outlaw the possession or distribution of pornography, especially child pornography. The pornography or obscenity statuses essentially make it an offense, often a minor offense, knowingly to display obscene materials. So pornography and obscenity statuses in the virtual world makes it an offense to possess, create, import, display, publish, or distribute pornography or other obscene materials. Stalking is a relatively new offense, but one that is defined with a fair amount of consistency. Generally, it consists of one more than one occasion following or being in the presence of another person for no lawful reason with the purpose of causing death or bodily injury or causing emotional distress by placing that person in reasonable fear of death or bodily injury. And generally one commits theft if he she unlawfully takes or exercises unlawful control over movable property of another with purpose to deprive him. And embezzlement, on the other hand, lies in exploiting a relationship with another to unlawfully take that person's property. Theft cybercrimes can involve the theft of information, the theft of money or property, and the theft of vandalism is generally defined as knowingly causing damage to or the destruction of any real or personal property of another, when the actor does not have the owner's effective consent to do so. Destructive conduct in the cyberspace is often characterized as cyber vandalism. So now that we briefly looked at what cybercrime is and some of the crime liabilities, let's get back to the case. Let's look at Aaron Swartz's achievements and some of his contributions. So Swartz was frequently described as a technical genius, and at age 14, Swartz helped to author the RSS web syndication specification that provided a standardized format to publish frequently updated works, such as blog entries, news headlines, audio and video content. And at 19, he co-programmed the social news entertainment website Reddit, which was sold to Condé Nast in 2006 for an undisclosed sum thought to be between 10 million and 20 million. And the Reddit site is still popular these days. In 2008, he co-wrote the Guerrilla Open Access Manifesto, which called for activists to liberate information locked up by corporations or publishers. In 2010, at the age of 23, he co-founded Demand Progress, an online advocacy group that successfully campaigned against internet censorship bills and attracted more than 1 million members. By 24, Swartz was a Harvard Research Fellow conducting studies on political corruptions. Now let's look at how it all began and what was on stake. So in September of 2010, only a few days before he began the JSTR download, Swartz turned up at a Google-sponsored conference on the Internet freedom in Budapest. Though he co-led a session called Online Free Expressions and Enforcing Ethics and Accountability for Corporations and Governments, he did not seem specially moved by the conference's formal proceedings. But one night he went out to dinner with a group of activists, including many who were involved in the journal campaign. They spoke about the outrageous sum of money it would take to free up JSTOR for public consumptions. So no one at the dinner proposed a massive JSTOR download or anything remotely like it. Swartz did not give any indication he had a specific battle plan in mind, but then Swartz didn't let on that he was planning to compose a manifesto either. So within a few days of returning to the United States, Swartz purchased a new laptop, logged into the MIT computer network, and began the liberation of JSTOR. So after noticing an aggressive number of downloads from JSTOR via the school's network, MIT technicians traced the source of downloads to the basement closet, where they found a hidden laptop had been connected. And after consulting with the police, they left the computer connected and rigged up the hidden camera to see who came back for it. In the video, Swartz can be seen taking a hard drive out of the cardboard box and then bending down out of the screen. So before the prosecution, Aaron went undetected because he would change his IP address each time the MIT server blocked his IP address. So by spoofing the IP address, he was able to download the mass content of the journals. So even before the JSTOR case, Swartz scraped documents from Pacer, the federal judiciary's paywalled website for public access to the court. And Malamud And Scholz at the time was Swartz's colleague who saw the pacer skipping project primarily as a way to pressure the judiciary to provide free public access to the full pacer database. Ever since 2008, Scholz has made pacer a major focus of his work, writing extensively about the case for tearing down pacer's paywall. So for the downloads to take place, Swartz asked a friend to go to a Sacramento library that was participating in the program. After the librarian logged the friend into the library's Pacer account, the friend extracted an authentication cookie set by the Pacer site. Because this cookie wasn't tied to any specific IP address, it allowed access to the library's Pacer account from anywhere on the internet. Later, Swartz admitted to Malamud that he didn't have the library's permission to use this cookie for offsite scraping. And it took a while for the courts to figure out what was happening. Swartz started his downloading in early September. On September 29, court administrators noticed the Sacramento library racked up a $1.5 million bill. The feds shut down the library's account. After that, the courts issued a vague statement about suspending the program, pending an evaluation. A few weeks later, a court official revealed law enforcement had been called to investigate the suspected security breach. So out of the 2.7 million documents, Words downloaded about 700 GB of data in all. Malamud discovered about 1,600 with privacy issues. He then sent a report to court administrator disclosing the poorly redacted documents he had found and encouraging the courts to examine the rest of the documents in Pacer to ferret out similar privacy problems. Both the FBI and the Department of Justice investigated the case. They identified Swartz via his ownership of the Amazon server used to crawl Pacer. Both agencies dropped the case by April 2009. Later that year, Swartz made an open record request for his own FBI file and briefly posted it online, calling it truly delightful. Now, even this case did not lead to his suicide, but the prosecution came on hard on Swartz because of his previous conducts. After Aaron's suicide and requests from many people, MIT released a report on their actions on the case. So let's look at some of the key findings. So, beginning in September 2010, MIT and JSTOR observed massive downloading of JSTOR articles by a laptop connected to MIT's network. The downloading recurred in October and December, and bypassed MIT's attempts to stop it. The scale of downloading was large enough that it threatened to shut down JSTOR's overall service. MIT did not learn that the person responsible for downloading was Aaron Swartz until after his arrest, on an initial charge of breaking and entering. MIT called in a Cambridge police detective to help with its investigation. The detective arrived on campus accompanied by a federal special agent of the Secret Service, but the report found that MIT did not intentionally call in the feds to take over the investigation. MIT did not request that federal charges be brought against Aaron Swartz. It was not consulted about its opinion about appropriate charges or punishment, and it did not offer any. MIT was not involved in any plea negotiations and was never asked by either the prosecution or the defense to approve or disapprove of any plea agreement. From early on in the prosecution, MIT adopted a position of neutrality. It did not issue any public statements in support of Aaron Swartz or against him. MIT privately communicated to the prosecutor's office that it should not think that MIT wanted jail time for Swartz. MIT did not advocate whether publicly or privately either for or against jail time. Until Aaron Swartz's suicide, few people urged MIT to take a position on the prosecution. The report notes that faculty were divided on the issue and there was little student interest. However, the report says that MIT's neutrality stance did not consider factors including that the defendant was an accomplished and well-known contributor to the internet technology, that the law under which he was charged is poorly drafted and questionable criminal law as applied to modern computing, and that the United States was pursuing an overtly aggressive prosecution. While MIT's position many have been prudent, the report says, it did not duly take into account the wider background of policy issues in which MIT people have traditionally been passionate leaders. Next, we will look more into the prosecution and amendment to the law.
The charges in prosecution. On 11 July 2011, a federal grand jury indicted Swartz for wire fraud, computer fraud, unlawfully obtaining information from a protected computer, and recklessly damaging a protected computer. The charges carried a maximum sentence of 35 years in prison. Swartz refused the plea deal, and on September 12, 2012, federal prosecutors added 9 more felony counts to under the Computer Fraud and Abuse Act, increasing the maximum prison time to 50 years. In all, Swartz was charged with 2 counts of wire fraud and 11 violations of the Computer Fraud and Abuse Act. Usually, wire fraud charges involving computers are prosecuted along with the CFAA. The essence of the prosecution's case depend on their interpretation and application of the CFAA. Swartz was arraigned in U.S. District Court in Boston, where he pleaded not guilty to all counts, free on a 100,000 unsecured bond. On 3rd June 2011, Swartz and GSTOR entered into a civil agreement. Pursuant to the agreement, Swartz certified that he made no copies of the downloaded files. Swartz paid $1,500 in damages and $25,000 in attorney's fee. Afterwards, GSTOR considered the matter closed and publicly declared its preference that Swartz not to be charged. GSTOR public statement states that, as noted previously, our interest was in securing the content. Once this was achieved, we had no interest in this becoming an ongoing legal matters. Up until Swartz's suicide, GSTOR's attorney contacted lead prosecutor Carmen Ortiz numerous times, reaffirming their wishes that charges against Swartz be dropped. People's and scholars' reaction to the law. Reaction to Swartz's death was very opinionated, dividing legal scholars and promoting public debate about whether Swartz was overcharged or whether he even committed a crime to begin with. Many legal scholars' reaction targeted the CFAA's harsh criminal treatment of Swartz in light of an intrusion that was neither malicious nor prolonged. Jennifer Gornick, Director of Civil Liberties for the Center of Internet and Society at Stanford Law School, wrote, "The CFAA is incredibly broad and covers swaths of online conduct that should not merit present time." Professor Oren Kerr recognized that the CFAA in its current form lead to undesired outcomes. The problem raised by the Swartz case is felony liability under the statute is triggered much too easily. The law needs to draw a distinction between low-level crimes and more serious crimes, and current law does so poorly. The back and forth correspondence publicized through blogs and online editorials differed in sympathy expressed towards Swartz, but agreed in principle that the CFAA no longer worked well as a viable, well-balanced computer crime statute. The history of computer crime law. Originally, the CFAA created 3 federal crimes limited to federal interest computers. These crimes were accessing national security information, private financial information, or a computer owned by the US government without authorization. A federal interest computer was any computer on which national security or private financial information was found. The CFAA's scope has been expanded through revisions. In the last 30 years, the CFAA has been amended 5 times. With each amendment, the scope of the CFAA has been enlarged. Today, the CFAA is over-inclusive of criminal activity, creating over-criminalization that is only checked by the prosecutorial discretion. There are 2 reasons for this. First, Congress never defined authorization. This creates a vagueness and has resulted in a circuit split between the 7th and 9th circuits. Second, the CFAA is a bright line rule with no exceptions. The first offense, codified at 1030A1, prohibited unauthorized access to a computer for the purpose of obtaining national security information with intent or reason to believe the information would be used against the USA's interest. The second offense, codified at 1030A2, prohibited authorized access to a computer to obtain financial information from an institution or consumer reporting agency. The third offense, codified at 1030A3, prohibited a person from unauthorized access to a government computer if doing so affected the computer's operation. The purpose of all three statutes was to protect three specific government interests. Currently, the phrase now reads "used in or affecting interstate or foreign commerce or communication." Affecting interstate commerce is a term of art showing congressional intent as far as legally permissible under the Commerce Clause. In application, the Commerce Clause gives the government power to regulate purely local activities that are part of an economic class of activities that have a substantial effect on interstate commerce. In effect, the CFA has almost blanket jurisdiction to criminalize any form of unauthorized access. Throughout every revision, Congress expanded the scope of the authorized use, but Congress never defined authorization. Furthermore, no exceptions were added despite the constant expansion of the criminalization, which engulfed previously innocuous actions. The result in the present day is that the CFAA is a blanket rule. Once triggered, its only constraint is prosecutorial discretion. There is a circuit split between 7th and 9th as each one interprets authorization differently. 7th Circuit interprets authorization more expansively than the 9th Circuit. The split emerged from employer-employee disputes about when an employee acts without authorization or exceeds authorization. The 7th Circuit ruled that an employee's authorization is terminated when the employee's action violates a duty of loyalty owed to the employer. The Ninth Circuit has declined to interpret authorization so broadly. Because Congress has no defined authorization, the Ninth Circuit interpreted the word according to its common meaning. It ruled that an employee's authorization only ends if the employer revokes it, even if the employee uses his authorization in a way that is harmful to the employer or in violation of state law. Bright line approach in proposal for change. The need for congressional reform. The CFAA is over-inclusive for two reasons. First, it criminalizes innocuous crimes. Second, it does not have exceptions permitting certain classes of person or excluding certain types of infractions. The only filter on the CFAA is prosecutorial discretion. This is not assuring because it is not clear that the government or at least every individual prosecutor can be trusted to make a responsible, sense-making, and unbiased decisions in every case. The Supreme Court can solve the first problem by solving the circuit split in favor of a BRCA case. The court cannot solve the second, that requires congressional action to amend the CFAA. Lack of exceptions. If a person does not have authorization or mistakenly goes beyond their authorization on a network, they may have committed a federal crime, despite having done an innocuous thing. This would eliminate vagueness and concretely define authorization, but it would not create an exception for situations when use is unauthorized, but does not rise to the level of criminality. For these reasons, Congress must step in and create an exception. Prosecutorial discretion. CFAA is criminal prosecution inherently lends itself to abuse of prosecutorial discretion. The problem is twofold, part human and part systematic. CFAA sentencing is determined according to a calculation of loss incurred. Sentences are more harsh and unpredictable than in other federal cases because the CFAA's definition of loss is very broad and not limited to foreseeable damages. Furthermore, The prosecution's definition of loss is very broad and not limited to foreseeable damages. Furthermore, the prosecution's burden of proof is very low. The effect is that many defendants are cornered into accepting a plea deal as their only rational legal option rather than opt for a trial and risk significant prison time and more expenses. Overcharge. Swartz was likely overcharged for two reasons. First, the discrepancy between prison time recommended by the government if Swartz went to trial versus if he took a plea deal. Second, the government's calculation of loss. Often, felons face social stigma, loss of job opportunities, and loss of voting rights, which they may never gain again. Furthermore, the judge is not restricted to the government's sentencing suggestions. Even if the government argued 4 to 6 months, Swartz had no absolute guarantee he would only have served that much. Swartz downloaded around 4.8 million articles from GSTOR. The cost to download was $19. The government could have argued Swartz caused anywhere from 10,000 to 91 million in damages to the GSTOR. The practical result is that the spectrum of loss calculations would have allowed the government to argue for any sentence it wanted. In this part of the presentation, I want to discuss and propose legislation reforms that could cause similar as just injustice like Swartz case. First is reform. It is inequitable and unconscionable for a hacker like Swartz to be charged without taking into account the operational reality of his actions. The CFAA should create a bright line exceptions to a general rule stating that in order for criminal liability to be established, an infraction must pass a certain threshold. If the infraction does not pass the threshold, then legal remedies should be limited to civil litigation. Congress should change the CFAA either through amendment or new legislation. The Hackers Rule. The Hackers Rule proposition is a two-part rule that abolishes the current bright line rule. The Hackers Rule would create an exception for when a person who uses a computer without authorization or exceed authorization is not criminally liable. A. If a hacker would be criminally liable if he acts with malicious intent, or 2. If no malicious intent or no federal interest, then his unauthorized intrusion was reckless enough that regardless of any civil or extrajudicial settlement with the injured party, traditional criminal conventions would seek to punish. Another proposal is a Malicious Intent Act. Privacy and computer security activist Chris Shahuyan, a senior policy analyst at the American Civil Liberties Union, suggests that existing law needs to differentiate between malicious and non-malicious intrusions by hackers for the purpose of showing off their skill or spreading information they believe should be available publicly. It is unlikely that Swartz would have been prosecuted under the proposed hacker rule. First, Swartz does not have malicious intent. Second, the damage he caused was sufficiently cured by his extrajudicial agreement with the GSTOR and was not reckless enough that the traditional criminal sanctions should seek to punish. And the last one is reckless use. The second part of the hacker's rule creates a general rule that if the hacker's intent is not malicious, the prosecution must show it was, nevertheless, reckless enough that the person should be punished, even if the person settled with the injured party. The government alleged he accessed GSTOR with the intent to defraud, but Swartz's mental state suggests otherwise. Even if the government argued that the Swartz download could have deprived GSTOR of a competitive advantage in attracting customers to sign up, Swartz's intent was not to enter the online journal database market with articles downloaded from GSTOR.
Overall, Aaron has multiple social titles. According to Wikipedia, he is an American computer programmer, writer, political organizer, and internet activist. Obviously, he is a technology geek who would like to share his opinions and ideas regarding political promotion and social changes. Aaron is a bridge of the two worlds of technology and activism. A young man driven by curiosity and the belief that information was the most valuable thing, a form of wealth no one should be deprived of. As a teenager programming genius, he had helped to develop RSS, which is still popular now, and allow users to self-syndicate information online. And when he was 19, he was one of the builders for Reddit, where social news aggregates, discussion happens, and contents are rated. Later on, Reddit was purchased by investors, which turned Aaron into a millionaire. Since then, he had become a tireless and innovative advocate for political and social changes. In 2011, for instance, he successfully led a campaign to prevent the Stop Online Piracy Act, a bill introduced to Congress that would have effectively legalized censorship on the internet. In July 2011, Aaron was arrested in Boston for several charges, including computer hacking and wire fraud, because he downloaded 4.8 million JSTOR papers and crashed some of its servers during the process. Furthermore, the fine for him is $1 million maximum, plus 35 years at max in prison. However, under normal circumstances, he would have been entitled to get them for free. It isn't a crime to download entire articles from JSTOR. In fact, many of us have done so in schools. Most college and university libraries pay for access to JSTOR so that their users, like teachers and students, are allowed to access the articles for free. Almost exactly 2 years from the day he was arrested, Aaron ended his life by hanging himself in his Brooklyn apartment. Let's look at some law aspects for this case. As we earlier mentioned, Aaron was charged with a maximum sentence of 35 years in prison and 11 violations of the Computer Fraud and Abuse Act 11 after Aaron was arrested. He pled not guilty to all courts. On June 3, 2011, Aaron and JSTOR entered into a civil agreement. In this agreement, Aaron declared that he did not misuse the downloaded copies of documents. Then Aaron paid $1,500 for damages and $25,000 for attorney's fee. Later, JSTOR confirmed that they have no questions with Aaron, and told the public they prefer not to charge Aaron, since their objective is to make sure that the content of their documents are secured. They contacted the lead prosecutor many times and expressed the idea that they did not want to sue Aaron again. However, the charges were still not dropped, and finally, the tragedy happened. As we earlier mentioned, CFAA is used to judge the case. However, it's too harsh to give a fair result in this case. First of all, it can turn innocuous crimes into real crimes. Second, the calculation of losses under CFAA is very broad, not only limited to foreseeable damages. In addition, the prosecution's burden of proof is very low. Many defendants have to plead guilty as the only legal choice rather than a trial. At the same time, they need to take on the risk for prison and compensation for losses. During the process of trial, the court usually refers to similar previous cases to judge the current cases. However, there is no previous similar cases for Aaron. The Congress needs to consider this situation thoroughly and created an exception for him. Aaron's actions do not bring any financial benefits for him or are not driven by malicious intent. He was not intended to be a competitor with JSTOR. Therefore, CFAA should be amended to deal with Aaron's case fairly. For example, they can set up a threshold to determine how to treat an infraction. If it does not pass the threshold, more likely in Aaron's case, it should be treated as civil litigation. According to Hacker's rule, Aaron's actions are not involved in malicious intent. In addition, even though the government stated Aaron's actions are not associated with the fraud, his mental state does not indicate that he has the intent to enter the online journal database market. Therefore, no reckless use exists in Aaron's case. Now, let's look at some comments from Aaron's family and friends. The first is from his girlfriend. He could not deal with people talking about him. It's taken me some time since he died to get used to talking about him because I was under such strict instructions not to. But he messed up something major. He made a really bad decision. And it's my right now to ignore all the other things that I thought were dumb too. Maybe if I hadn't felt I could talk about him to other people, this wouldn't have happened. I'm not going to let those preferences that led in one way or another to him killing himself guide my life anymore. I reject them. From her words, even though she blamed Aaron's decision to die so hard, I can still feel she loves Aaron deeply. The more love she has, the more blame she gives. I personally agree with her that Aaron finally made the worst decision ever to put his life to the end, even though he went through mental and financial pressure from the charges. He should not give up the most valuable thing in the world. The next is from one of Aaron's friends. I look back at my emails, and I was almost always the one who didn't continue the conversation. He would always say something nice, and most of the time I didn't respond. It made me feel like a bad person. We can see Aaron has nice personality and take care of others' feelings. That's Aaron's ethics standards, just like he would like to speak for the public to make political and social changes. And the last one is from Aaron's father, which might be the closest reason why Aaron suicided himself. I will tell the following story, which is perhaps the best way I can describe what may have happened. The last few weeks have been the hardest weeks of my life. I think I have managed poorly, but okay. But because I was so hungry, I was feeling increasingly bad. And I went home and thought I was going to have a nervous breakdown, which for me never happens. I will get depressed as we all do. And I'm certainly very depressed right now. But I can sort of manage and see my way through. I said to Susan, I'm really not feeling well, and I sort of think I'm losing it. I got something to eat, and I still was feeling very crummy. And then I had dinner, and I still didn't feel well at all. And I went to sleep and woke up in the morning, started feeling better again. I seem to have righted the ship. So part of me thinks that maybe something happened with all the other things that we were going on that just put him in some the dissociated frame of mind. There were times when Aaron where he would suddenly not be himself for a short period of time. That's the best explanation I have. Aaron's father might be the one who knows Aaron best. From his words, we can tell Aaron might be depressed for a short period of time because of the mental and financial pressure posed by the litigation for 2 years. The negative emotions for him peaked at the time, which leads to his suicide. The life of the young genius ended in a sudden way that made most people feel sorry. Aaron's death brought much sadness to his parents, girlfriend, and friends. In addition, it's also loss to the whole society because we lost a young pioneer who speaks for the public. The case also triggers us to feel that legal system should treat every case accordingly and make every decision carefully. Here are our references.